Okay, we are here at the Thomas S. Foley U.S. Courthouse on public property on the outside of the courthouse doing jury outreach, and we're going to go ahead and do a little brief training. This is in regards to a long-term jury education program that we're going to be doing here in Washington and California and all the other states. So what we're going to be doing is we have Kirsten Tynan from the Fully Informed Jury Association. We have Sharon and Kristen and Kathy Z from the Human Solution. And we're going to go and do a little overview of good practices in starting a jury outreach campaign. Go ahead, Kristen.
Okay.
Kirsten. I get confused. You got to put up with me for a second.
Ooh,
Kirsten.
that's
Pretty. Look at
We like the wrapped bus idea.
Yeah.
Wouldn't that be fun? Jury nullification.
That actually doesn't seem like a bad idea. Okay.
All right, let's go ahead and tell us what, some good practices and...
So what we did first was we walked the whole courthouse area, walked around, well, we haven't gone on that side, but that's actually, I think, the post office over there, so that's okay. But we walked the grounds to understand, where the entrance is, where jurors may park or may not park, where we can park, where we can go to the bathroom. The library, by the way, I checked, has a nice bathroom.
Thank you.
And we're also right across from the Spokesman Review here, so that's local
It so
media.
happens to be
Good
our
know.
local media.
Yes. So we are going to do general juror education outreach today, and so we're going to start with where we're going to be. We're going to be on the public sidewalk here. We are not going to go on the courthouse grounds for this. The public sidewalk is well established as an area of free speech, and the courthouse is usually hostile to our information, so they're going to do everything they can to try and keep people from handing it out. So we're going to not go on their campus, I guess I'll call it, compound.
The compound, yeah.
Yeah, they got
That's a
some
good
concrete
word
poles,
for
so
it.
yeah, that's
So we're going to
compound.
stick to the public sidewalk. And so for this courthouse, the delineation appears to me to be this like sewer grate here.
Right, yeah, the
But-
sidewalk is actually on the other side of it.
But what I would say, we want to be sure that we do not let anyone, have any way of saying we're blocking the sidewalk or anything. So for me, I would say I would leave these 3 squares for people to walk. I would probably stand here and offer literature from here. I might have my jury rights day postcards.
I'll pretend to be a walker.
Right, so if you're walking by, ma'am, would you like some information about your rights as a juror?
Oh, and what organization are you with?
We're with the Fully Informed Jury Association. Our information's right here.
Oh, very good.
Or
very
if
good.
you were using the Human Solution literature. do
Oh,
that.
thank you very much.
And
here.
if they don't want it, we're not going to harass them.
Nope.
If we
No.
don't want anyone to have any grounds to complain about us, we'll just say thank you and have a nice day.
Exactly.
So that's what I would do. I would stand in these.
So
these
we're
two.
establishing a place where we're going to be. We're giving the pedestrians 3 squares.
Yeah,
We're going to take
plenty of
2.
room.
They can never say that we're impeding the
Right,
sidewalk.
Exactly.
And we don't have any amplified sound, so they can't
Right.
give us grief over that.
The next thing I'm going to do, I'm going to make sure that I offer literature to everyone who goes by. I don't want to know who they are. I don't care if they're a juror. I am here to do general education. If they are a juror and I don't know, that's better for me. It's not like I was seeking them out. When you are handing out jury literature at a courthouse, oftentimes they want to say you're jury tampering. And so we don't do that because A, we don't seek out jurors to talk to. We don't try to sway their opinion. We just give them the information. What they do with it is none of our business. We don't talk about any case in progress, because if you're talking about a specific case in progress, that often opens the door, even if they can't make it stick, to make the accusation, maybe
Oh, they'll
even
try
legally
for sure.
harass you.
Right.
So we don't want to talk about any specific case in progress. And so we separate court support and advocacy from juror outreach. And the other thing we want to do is we need to get long-term, campaign going. We don't want to just show up the day
Not
of
just
a
for this
particular
case,
trial of
right?
interest.
Or that case or the other case.
Exactly. we're not here to advocate for or against that case. And if we show up and do a long-term general outreach campaign, we are making the statement that we're part of the landscape,
Right.
that we are not here related to any particular case. And it is actually better for, in general for the community, because there are many, many cases that this information might be something that a juror could use. So we get that information out there. Okay. Yeah.
So beyond handing out literature, what happens when we have somebody that does engage you? Because oftentimes that happens.
Okay. So sometimes someone will ask me a question. They'll take the literature and ask me a question, and I'll either answer it from my knowledge, which everyone will have after tomorrow's training.
Yeah, I can be the kind of
okay,
questions.
so whatever questions you might have,
Well,
throw 'em
is
at me.
there this is an 800 number.
Uh-huh,
Is there
right.
a local group doing this as well?
I hope there will be.
We're hoping for that. Here,
Very
Kathy, you need to
good.
get a little
Yeah.
closer.
Oh, thank you.
So, so one of the questions I've been asked is like, don't jurors already? They can vote their conscience already, right?
Oh, don't they already know
Yeah.
this?
You know what? They can vote their conscience already, but what they don't realize is that includes setting aside the law when a just verdict requires it. They are not required to vote guilty if they think the law has been broken. If they believe that a just verdict would be not guilty, even if the law has been broken, they can vote not guilty and they can't be punished for their verdict.
But when I was in court the other day, I heard the judge say that I didn't have that right.
Right. Yeah, if you're,
Isn't that, do you get that question?
Yeah, no, because usually someone's not going to tell me they're a juror.
Okay.
Because jurors are told that they are not to
No,
talk
I
to
didn't
anyone.
say I was a juror.
I know. But the judge wouldn't be telling you that if you weren't a
No,
juror.
I sit in court all the time. I hear
okay.
this constantly.
Okay, so you're like if you were
I'm
an
a
observer.
court supporter. Oh, so
Okay.
maybe I should have said,
Okay.
I'm a court supporter.
Okay.
And the jury is told all
Yes,
every
right.
case.
That I might hear, right.
Okay.
And it's true that they're often told that, and unfortunately, court cases have been decided such that judges are able to provide misinformation to jurors. So the only way they're going to find out the accurate information is if we reach out to the community ahead of time and reinstill this as part of the community knowledge. We want them to know, just as everyone already knows they could get called for jury duty. We want the same level of knowledge that everyone knows that they have a right to vote not guilty if they conscientiously believe a just verdict requires it.
Where did this right come from?
This actually is part of a tradition of English common law that was brought over to the United States by colonists who expected to have the same rights that they were afforded as, English residents. They came over here, and a number of their rights were not respected. They were basically just treated as money makers for the country. And that is actually part of the reason we had an American Revolution. If you look in the grievances listed in the Declaration of Independence, the denial of the benefits of the right to trial by jury is one of those grievances. It doesn't just say the denial of right to trial by jury, it says denial of the benefits of right to trial by jury. And one of those benefits is the ability for jurors to judge the law as well as the facts. And so that was built into our legal system by aggrieved colonists who were not appreciative of having their rights disrespected by England. And so we have it today by virtue of two facts. First of all, jurors can't be punished for their verdicts. This dates back to 1670, the case of William Penn, who was tried for preaching the Quaker religion in England against the England's Conventicle Act, and his jurors refused to convict him. And they were punished, they were jailed, they had food and water withheld from them, and they still wouldn't change their verdict. And some of them appealed their punishment to a higher court, and that higher court ruled that jurors could not be punished for their verdict. And so we celebrate Jury Rights Day every September 5th in commemoration of that. So we still have that today. Jurors cannot be punished for their verdict. There are things jurors can do that they can be punished for. If they are told they're not allowed to do outside research on the case or things like that, those are things that they can get punished for, but they cannot be punished for voting not guilty. The other feature of our system that really puts teeth in this power is that once a defendant is outright acquitted, they cannot be retried. It's called no double jeopardy. And so if a jury unanimously acquits someone, even if they broke the law, they can't be retried. And so in that sense, the law is nullified. It's called jury nullification. So,
Oh, okay.
yeah.
Thank you. That really helps.
So if you know the answer to the question, answer it. If you don't know the answer, feel free to direct them to the 800 number. They can get a free jury power information kit sent to them. And also our website, they can find out how to reach us and ask us the question directly. So it's okay if you don't know the answer. Don't be afraid to say, you know what, I'm going to refer you to the national office on that one. Or, I'm going to refer you to someone else at the Human Solution if it's a question like that. Don't be afraid to say that you don't know. We're not, you don't have to be an expert. And most people are going to, if they're interested in this, they're going to do a little more research on it themselves anyway, because they're going to be like, can that be right?
Exactly.
So,
well, and it's maybe a good reason to have a bunch of people there in your little group when you're doing jury rights day, because you'll learn as you're going. By the time you're done with your day, you'll be real good at this.
Yeah. You do one day of this and
there's only so many questions.
Yeah, you get some questions you can't answer, you go look them up, pretty much the same questions next time. It's very rare that I have had a question that I had not been asked before.
Well, what do you say when people come at you with the old adage of, well, back in the 50s, they reverse nullified and they refused to acquit people that were guilty of lynching people?
Yeah, that is actually often blamed on jury nullification, but if you look at the conditions that allowed that to happen, in, for example, the Emmett Till case, there was no person in that county who was black who was allowed to be a juror. It was an all-white jury by law. That was a problem with the law, not so much with jury nullification. And if you look at how juries work, at the end of the trial, you don't have 12 individuals in isolation, each voting, and then you're done. They go back and they deliberate, and they do that for a reason. And that is because it's a dynamic process in which they have to look each other in the face and say, I honestly believe this. And it has been shown that when you have people of color on juries, the huge disparities that we see in conviction rates, especially when the so-called victim, if there is one, is of a different color, that those conviction rates balance much better when there are people of color on the juries. So in the 50s, that was largely a product of the system being set up for conviction of people of color. Now, we still have this power of nullification today, and any of these people, if there's someone who's racist and they want to vote not guilty when an actual crime has been committed, me not using this tool to help someone is not going to stop them from doing that. In that case, if there is a hung jury because someone is racist, that case can be tried again. So there is a fail-safe there to where you can get another jury, perhaps with more conscientious people on it, and try that again. And in a serious case such as murder, it's very likely that it's going to be retried. Now, if I am on, say, a pot possession case, or maybe, for example, well, I won't talk about that because that's a case in progress, but say I'm on a victimless, a case with no actual victim. Someone did something that just offended someone's sensibilities, and that person who's a defendant, they're black, or they're Latino, or otherwise, a person of color, then what happens when I convict them? A, I take them out of the jury pool for the length of their stay in jail. B, I'm going to likely take them out of the jury pool permanently because they're, in many places, aren't eligible for a jury ever again. Or if they're officially eligible, they won't be put on a jury once in the voir dire process it comes out that they are familiar with the system and the injustices thereof. So essentially, if I refuse to exercise jury nullification, I am reducing the number of people of color who will be on juries. And what did I just say before? I said that studies have shown that when people of color are on juries, we have much more just outcomes in verdicts. So I am not helping anyone by shunning this tool because someone else uses it wrongly. So.
Excellent. All right, Kirsten. Well, I think we have a lot of great information, and there will be more to come. Thank you so
Okay.
much.